Greetings and welcome to From the Basement. This video is going to be a little bit different from most of the ones on my channel, in that we're going to take a look at intellectual property laws for the United States of America. Intellectual property law is something that any creator, especially game creators, is going to have to worry about because there's a couple of little gotchas there. So, first of all, what is intellectual property law? Intellectual property law is the law that governs ownership of intangible things, such as a story or a song or a process of doing something, the goodwill associated with the company's name, these kinds of things. That's what intellectual property law covers. Now, before we get too much deeper into this, I do want to do a quick disclaimer here. I am not a lawyer. If you have a serious legal question, then please go consult an attorney that practices in the appropriate area of law. Do not rely solely on this guide. It is as accurate and as correct as I am capable of making it, but any area of law is a complex field. Intellectual property law is a complex field. Do not rely solely on this. This is an introduction. Furthermore, this only applies to the United States of America. Now, many countries will have similar laws and similar concepts, but please make sure you consult your country's laws before trying to make decisions. So make sure you understand your country's laws. Finally, keep in mind that this was created in 2015. Laws change. Now, always worth double checking to make sure that something hasn't changed drastically. Alright, enough disclaimers. Let's get back to it. There are three main types of intellectual property law: patents, trademarks, and copyrights. For game creators, unless you're dealing with a big company, patents are the ones you're going to deal with least. You'll probably deal with trademarks a little bit, and copyrights really kind of where we live as game developers. First, let's take a look at patents. Like I said, this is the one you're most likely to have the least amount of contact with. Unless you are doing hardware development or you're doing like game engine development, generally speaking, patents aren't going to be something that you're going to worry about. A patent covers a specific way of doing something. So like the circuit board that makes up your graphics card, or the chemical composition of a drug, how to assemble that chemical composition to fight off arthritis or what have you. Those are the types of things that are covered by patents. You can cover algorithms, you can cover software with a patent, but generally speaking, this is quite difficult to do. Software patents are actually one of the more difficult and consequently one of the more expensive patents that you can get. You will need a lawyer to get a patent, and you can expect to spend between $6,000 to $10,000 acquiring this patent. Yeah, they're expensive. Like I said, unless you're at a big company doing hardware stuff or game engine stuff, probably not something you're going to be worrying about. Trademarks. Now, trademarks are something that you have to worry about. A trademark protects corporate and product identity. Many gamers, if they see a game is produced by Blizzard Entertainment, that's an automatic buy. Or if they see the Call of Duty label on a game, that is an automatic buy. The goodwill associated with these names is very valuable, commercially speaking. And so trademarks protect that. Blizzard does not want people putting out junk games under their name because that would damage their reputation. So they have a trademark on their name. Trademarks have to be actively used. It's difficult to troll with a trademark. It's possible, but yeah, a trademark has to be in active use in order for it to be valid. Also, trademarks must be actively defended. If you do not defend your trademark, you will lose it. It's very easy to lose. As an example of this, back in 2011, Bethesda the creators of the Elder Scrolls, Skyrim, brought legal action against Mojang Studios, which of course is responsible for Minecraft. And what happened is Mojang Studios attempted to trademark the word scrolls because, well, they've got a game called Scrolls, so they wanted to trademark that word. They didn't want another game out there called Scrolls. Fair enough, if a little odd, but you know, they've got a game, they want to protect that game's identity. They got the trademark in their home country. However, when they applied for it with the U.S. office, the U.S. Patent Office denied it, citing potential consumer confusion with the Elder Scrolls trademark, which of course is held by Bethesda. At this point, Bethesda had no choice. They had to take action. They were a bit unfairly raked over the coals by the internet mob over this. But honestly, they didn't have a choice. The U.S. Patent and Trademark Office itself stated that there could be consumer confusion. And if they had not gone after Mojang Studios, that would have been seen as them basically abandoning their trademark. And so someone could have come along and tried to use it, and they might have been able to succeed. You know, it's happened multiple times throughout the industry of a company not aggressively defending their trademark and losing control over it. So trademarks have to be aggressively defended, which honestly it does cause problems sometimes, but that's just the way they work. All right, copyright. This is the one we're going to spend the most time on because it's really kind of the most relevant for content creators, especially for game or mod developers. And what a copyright does is a copyright protects a specific expression of an idea, but not the idea itself. So for example, if I want to write a story about a young boy who discovers he's a wizard and he goes off to a magical castle to learn how to use magic and makes a couple of best friends, and the school is ran by this old, slightly crackpot wizard, and they have all sorts of adventures. Yeah, there's nothing that J.K. Rowling can do about it. She doesn't own the idea of children going off to magic school. No. Now, if I try to set my story in Hogwarts, yeah, I've got problems now. At that point, yes, I am using her world to write the story, and that's a no-no. Likewise, if I wanted to make a game where I go out into the wild and capture monsters and train them and bring them into tournaments and battle them, yeah, nothing Nintendo can do about it. As a matter of fact, that describes multiple different games. Dragon Warrior Monsters, produced by Square Enix. My personal nickname for them is Squeenix. Dragon Warrior Monsters, pretty much exactly that. You go out, you capture monsters, you train them, and you fight them in tournaments. Now, if I have an electric rat featuring as one of my primary characters, and the monsters are contained in red and white squares or balls, yeah, I'm asking for Nintendo to get involved in this. Copyright is kind of a really gray area. Is something infringing or is it not? Is something just simply inspired by, or is it a copy? There's a lot of gray, murky area there. To make it even murkier, we have this concept called fair use. Now, fair use is kind of like this a legal loophole to allow you to use somebody else's copyrighted material. Generally speaking, this is intended to protect critique, movie reviews, game reviews, book reviews, that sort of thing. I mean, you got to use pieces of the original work to really be able to critique it well. And educational use as well. One thing that I see a lot of people make a mistake on is they think that, well, if I don't charge money for it, it's fair use. Wrong. Money is but one factor involved in fair use. When a fair use case comes up, the judge will look at a variety of factors, including, is the potentially infringing work being sold for money? Was the original work being sold for money? How much of the original work was being used? And how transformative is the new work? In other words, how much has it changed? The more you transform or the more you alter the original work, the stronger your fair use claim is. And the less you use of the original work, the stronger your claim is. And not charging money also really helps too. I'm not saying that not charging money doesn't help, it's just not an ironclad defense. So for example, Weird Al Yankovic's, he does parody songs. For example, Michael Jackson has a song called Bad. Weird Al has a song called Fat. And it's instantly identifiable. If you listen to Bad, then you listen to Fat, it's like, oh yeah, obviously Fat's taken from Bad. There's no question of it. But he drastically alters the song. I mean, completely rewrites the lyrics. He re-records all of the sound. He doesn't use the original sound. And he also, as a matter of professional courtesy, will get permission from the artist, generally speaking, that he's making the parody song on. He doesn't have to, mind. That's just a professional courtesy that he extends to his fellow artists. But, you know, he doesn't have to do that. Parody, humor is protected by free speech. Likewise, Total Biscuit or Jim Sterling, when they do their reviews of games and they embed gameplay footage in there, that is fair use. I mean, what? They've got, depending on the video, between 10 to 20 minutes of game footage from a game that presumably would take at least 4 to 6 hours to complete. It's a fairly small slice of work there. So yeah, the more transformative it is and the less you use of it, the better off you're going to be. Fair use gets really, really murky though. Perfect example of this are AMVs or animated music videos. They're pretty common on YouTube. There's actually several really big sites dedicated toward these things. And what it is these AMV creators, they will take a game. Most frequently, they'll take an anime. They'll slice it up, recombine various little pieces of the anime, and put it to a song and post it as a music video. There's two components to this. The anime component actually has a really strong fair use argument. Generally speaking, a song's only going to last, depending on the song, between 2 to 5 minutes. Or let's say 3 to 5 minutes. 3 to 5 minutes out of, even if it's just a single movie, 3 to 5 minutes out of an hour-long movie, that's a fairly small portion of the work, so it passes that test. Generally speaking, these are not being posted for profit, so that helps them out as well. And they're not just simply, well, the good ones, don't just simply show 3 continuous minutes of the anime. They slice it up, take a scene from this bit and a few frames from this bit and a few frames from that bit, and recombine them in a new sequence, giving new meaning potentially to that sequence of animation frames. So there is a transformative nature to it as well. So the visual part of it actually has a really strong argument for being fair use. The song, however, fails almost every test. They're using the entirety of the work. It is the entire song that they are using. They are not transforming it in any way either. It's the entire song, not sped up, not slowed down, just boom, there it is, the whole song. And even though these videos aren't being shown for profit, the original song is being sold for profit. And so, yeah, the song portion's really, really weak. You could potentially argue that the song is transformed by having these images, juxtaposed along with the song, which could grant new meaning to the lyrics, but that's weak. That's really weak. So it's a real murky area, which brings us into the final point. When it comes to copyright claims, you are guilty until proven innocent. All right, perhaps that's a little bit dramatic. That would definitely be a clickbait title if this was a link title. But there's a fair amount of truth to that. You got to keep in mind that most copyright cases, unless it involves like piracy, like you've gone and you've sold, 10,000 copies of somebody else's work, yeah, that's a separate issue. But if it's just a matter of whether or not your game or your mod or what have you infringes upon somebody else's intellectual property, generally speaking, that's going to be a civil, not a criminal case, especially if it's a fair use case. Fair use cases, to my knowledge, are almost always civil cases, which means the burden of proof disappears from the accuser. You now have to prove that you have the right to use the work, which means you have to be able to afford to prove that you have the right to use the work. And so if you end up going up against somebody like, say, Nintendo, who most likely has much deeper pockets than you do, suddenly it becomes much less who's actually right and far more so who can afford the better lawyers and continue to pay them the longest. A little bit brutal, but that's kind of the reality of copyright. So your best bet is to not poke the hornet's nest and stay away from things that could be violating copyright. Or if you are going to poke the hornet's nest, just be aware of what you're doing. There's a couple of companies, by the way, that you just simply don't mess with. Nintendo's one of them. They're pretty aggressive in terms of protecting their intellectual properties. Disney's another one. The House of the Mouse. You do not mess with the House of the Mouse. They are very aggressive in protecting their intellectual properties. So, Star Wars fans, beware. It remains to be seen how vigorous they will be defending their IP. All right, one final thing here. How do we apply for these? Well, trademark and patents go through the U.S. Patent and Trademark Office, uspto.gov. Quick side here, when you're going to these sites, make sure you are going to .gov, not .com. Any government-related site needs to end in .gov. There are a lot of places out there that, there is, I can assure you that there is a copyright.com, that there is a uspto.com. Don't go to them. They have nothing to do with the actual government sites. They're just trying to scam you out of some money. Trademarks are fairly straightforward for applying for. You can do those by yourself through the web. I believe it's a couple $100s to apply for a trademark. And there is a maintenance fee, a yearly maintenance fee, by the way, on trademarks. Again, remember, you have to be actively using it. You get a year to ramp up your business, but if you don't start actively using the trademark within a year, you're going to lose it. Now, when I say actively using, that means you got to be putting it out there. So if your game's going to be in development for 3 years, by all means, get the trademark now, and just put out updates and press releases and things like that. That counts. You just can't go total stealth mode for 3 years and expect to hold on to the trademark. And as mentioned earlier, patents, don't try to do it yourself. It is technically possible. There's no law saying that you must have a lawyer, but those things are nasty, complicated, and yeah, you're going to need a lawyer to get through that process. Copyrights are the easiest out of all of them. Anything that you put into a fixed format has a copyright automatically granted to it. You sketch out a map on a piece of paper. There's a copyright associated with that map. You write an email. There's a copyright associated with that email. That's why, by the way, if you look at the user term agreements for somebody like Google or Facebook or Twitter, there's language in there saying that you basically grant Google, let's say for Gmail, a unlimited, irrevocable license to use your work, because they have to have that to make copies of your work and transfer it amongst their cloud servers. They must have that. You own your email, and so you've got to give Google the right to make copies of your email. This also applies to homework assignments for students, by the way, unless you have waived that right through the student agreement or the college rules. At Johnson County Community College, there is no such thing. You own full rights on all of your homework assignments that you turn in. This is not the case in all colleges. DigiPen and Full Sail, for example, two of the more well-recognized gaming colleges, they own anything and everything that you turn into them. Some years back, I think 5-6 years back, this actually caused problems for a graduating group of students. The game that they produced as their graduation game attracted quite a bit of attention from publishers. They got some interest. They was like, hey, why don't you polish this up and we can help you publish it? And so the students went to the college, and the college was like, no, you signed the agreement. This belongs to us. Don't ask again. Non-negotiable. It is ours. We're keeping it. Shoot. Make sure you read your student agreements. Understand what rights you are assigning to the college or the school that you are going to for your work. All right, so getting back to this automatic grant thing here, about the only right that gives you is effectively the ability to stop somebody from using your work. You don't get any sort of financial compensation except for very specific cases. If you want to be able to seek financial damages against somebody, you need to register it. Registering your copyright also has the advantage of timestamping when you created your work. In the case it comes down to an argument of, well, I created mine before yours type of thing. I haven't seen this rumor, by the way, for a while. There used to be a rumor, though, going around the net that all you had to do to timestamp your work was to send a copy of it to yourself in a sealed envelope and then not open it. No, that has would not have any relevance in a court. If you want a timestamp, you register your copyright with copyright.gov. It's a very quick process. It's like $30 per registration. You can do it through online. Very simple process. It's not a hassle. And it gives you actually some pretty nasty legal teeth to protect your work. All right. Well, I think that just about wraps things up. I just want to sort of close this out with a reminder of, once again, I am not a lawyer. If you've got an actual legal question, please go talk to a lawyer that practices in the appropriate area of law. If you have a legitimate question, a legitimate concern about a project that you are doing, it is worth the $200 or $300 that you are going to spend to have a brief consultation over your issue. It's worth it. Please don't take this presentation as gospel truth. It is as accurate and as correct as I am capable of making it. But still, not a lawyer. Make sure you consult a real one for real questions. And remember, don't poke the hornet's nest. Chances are you're either a mod creator, student, or an indie developer if you're listening to this. The corporation's got much deeper pockets than you do. So just be aware if you poke the hornet's nest. All right, well, that wraps things up. Thank you for listening. Until next time.